some of the worst law in the insurance world was made by people who aren't coverage lawyers and are just making arguments that may have emotional appeal to them, or they're making form arguments without either understanding the evolution of the policies or are, just they don't appreciate the fine details that we do. And they look at something and they say, wow, this sounds really, really good. Let's argue it.
Welcome to The Defense Never Rests with Morgan and Akins, your monthly dose of uncommon sense about all things legal and some that are not.
Hey, everybody. Welcome to The Defense Never Rests. I am your host, Patricia Baxter, and today we are talking coverage. If you're one of those people that think handling coverage claims is boring, then this is the episode for you because we're going to flip that around. And we have three fascinating insurance experts, gurus that are going to change your mind. Before we get into it, though, I just want to say if you like what we're doing, I would love for you to hit subscribe on whatever podcast channel you're listening to. Give us a like, a rating. We're also on YouTube, The Legal Navigator. Subscribe there. Whatever you're doing, we would love the support. So thanks in advance. So today, before we jump into the episode, I want to introduce our three guests. I'll go ladies first. All three guests have a national practice in insurance coverage. They do tend to focus in on a couple states. Laura Gregory from Boston, Mass. Hey, how are you, Laura?
I'm good. Good morning.
Thanks for coming on. Next up, Michael Young, who is based in St. Louis, Missouri. Hey, Michael, how are you?
I'm good. I'm actually doing this from my house right now, but don't worry, I'm not self-quarantining.
No coronavirus for you.
No, I mean, there's a lot of people that want to quarantine me, but we're not quite there yet.
Not today. And then last but certainly not least, Scott Rybny, my insurance guru partner, and he handles PA, New Jersey, and New York. Scott, welcome back to the podcast.
Thank you very much. Good morning, everyone.
So this episode is all about, like I said, what it's like to handle insurance claims. About 15 years ago, I handled first and third party property work for about a year, which is enough only to say that I can issue spot. I could never handle an insurance coverage claim solo, but I can issue spot. And that year gave me an appreciation for the people that live it and breathe it every day. There is a certain person and a certain skill set that really excels in the insurance coverage arena. And I would say, detail-oriented, meticulous, analytical, patient. We all think that all lawyers should be like that, but the fact of the matter is there's some practices that I think really highlight those skills as necessary more than others, and this is an insurance, and that's today. That's the insurance coverage one today. So let's get into it. I'm going to throw it to you, Laura. Tell me briefly your journey, what kinds of claims you're doing, what you're handling these days.
Well, I ended up doing coverage by accident, which is probably how most people end up in this area. I worked for an insurance law professor while I was in law school. That sort of started getting me interested. Then I ended up working a summer with an attorney that did partially defense, partially coverage, and really liked the coverage. Also found out along the way, most people don't want to touch coverage with the 10-foot pole. So
that's so true.
Exactly. If it's something that you like, then you should go with it. I also like writing and the analysis, and coverage is new every time. Even though you know a policy really well, there are new twists on everything that make you think about it. And I like that mental exercise. So something I enjoy. I have done coverage under many different policies, both first party and third party. Lately, I've probably done more personal lines, but I did CGL almost exclusively for a number of years. That's commercial general liability policies. So also have done a bunch of first party cases. Those seem to be more at issue than they have been historically. So they're certainly an area that all of us, I think, are getting more expertise in, whether we like it or not.
What about you, Michael? Tell us your journey.
Well, I'm a partner at Hepper Broom in St. Louis, been doing insurance coverage for about 18 years. My hairline doesn't show it, but it's true. have always just found it super interesting. When I was a little boy on the playground, I dreamed of becoming an insurance company. No, I didn't.
I was like, where is this going?
Yeah. This this kid's messed up. But I do coverage work, which gets me the nickname in my office of Mr. Excitement. But it's really one of these things that I sort of, like Laura, just kind of fell into. When I started practicing, I did a little bit of everything. Slip and falls, motor vehicle accidents, commercial cases, and over time, people just kind of figured out, maybe Michael could read and write a little bit, and so the insurance cover work just started to come my way over time. Practicing in Missouri, there's really been sort of a real change in my practice over the last 10 years, because when I started, we were filing deck actions and writing coverage opinions and summary judgment motions left and right. And as our state has changed into a more of a bad faith state, we're so much more almost like an outside general counsel for a lot of companies, and doing a lot more consulting work and advising on things. So Laura's right. It's ever changing. It's interesting, and it's a lot of fun. So those are the kind of things that we're working on.
How about you, Scott?
I feel like I'm the older one now out of the group. I've been practicing the coverage work for just about 20 years now.
No, I got you beat there, Scott. I'm 28 years. So.
Okay. Well, you look so much younger than me. I couldn't tell. So.
Oh, excellent. I love that.
Scott's got this down, man. He knows what to say.
I was going to say, on your list of, characteristics of coverage lawyers, you left out good looking.
It's funny you say that, Mike, because there are really two reasons why I got involved in this. The first and primary reason was because of an argument with another attorney who I used to work with on a coverage matter. And I started out like a lot of the people doing the liability work for about 6 months. And we were just having an argument about something in a policy that was kind of coming in, and bad faith in Pennsylvania was a little more established. It wasn't quite the Wild West, but there was still a lot of area for debate. And it came to the point where the attorney said, look, if you think you can do better, prove it. So I said, okay, I'll take that challenge. And then I jumped into the coverage world. And one of the biggest challenges wasn't so much the policy language. It wasn't the lack of the law on a given topic. It was, how do you go into court, stand in front of a judge and 12 people who all they want to do is get money out of the insurance company, and try and convince them that your client really isn't the bad person here, that they're actually right, and that they're sympathetic, and there's reasons why they should be sympathetic. And it's a real challenge, but it's one that I've thoroughly embraced and I enjoy doing. And what it's done is, if you were to press me and say, Scott, in your heart of hearts, where are you? I'm a property lawyer. For whatever reason, I like the first party property stuff. And that runs the gambit from, the homeowners policies all the way through trade credit insurance, where you've got companies, issuing, policies based on, less than 6 minutes of notice because of a multi-million-dollar construction machinery transaction there. It covers so much ground that it's really enjoyable. And there aren't a lot of people who know it, who can, like Trish said, issue spot right from the very beginning here and say, okay, this is where you gotta get to, or as what Mike was saying, be able to look around the corner, which is where our role as coverage lawyers, I think, has changed a lot more from, okay, the facts are already laid out. Now, are we right or are we wrong, to, okay, people coming to us saying, hey, we're seeing something that doesn't feel quite right. What do we need to do to get to the point where we can make an informed decision? So our roles have certainly changed over time.
Well, and it sounds like, listen to all you guys, that it's you kind of stumble into it. Is that right, Laura? I think you said most people do stumble into it, but you come to it with some GL experience, and then you move into coverage, and you like the coverage. Do you guys sound like you all like the coverage better than the GL side? Is that fair or not?
That's true for me. I like the intellectual challenge, and it seems like the GL side, just the straight liability is much more about the facts, and getting that information out in a variety of different ways. Whereas coverage facts are one component, and then there's the application of the policy as well as the case law. So it's always a intellectual exercise, which I like.
Yeah, I think so too. I mean, it's, I'll hear people in the office talk about they took a deposition and they got this medical, and boy, they, this is this exciting, because look at this, or, look at this engineering report. And I'm just like, yawn, I'm like, that's cool, but like, check out this new endorsement, the CI provision is a little bit different. I think we're kind of like the little boy in The Sixth Sense that could see dead people. I think it's a lot like that.
That's awesome. Well, let me throw a question at you. How would you describe what you do to your kids or a family member that isn't in the law or in the insurance profession? I'll throw this one to you, Mike.
Goodness, what do I do to my kids? It's more like, what do they do to me? I honestly, I tried to keep up with them as much as possible. We just had my two daughters do figure skating. We had a big figure skating competition over the past weekend. And, sometimes you do better than you think you're going to do. And we had a situation where people were upset. And I said, I don't know what to say because I don't know anything about figure skating, shockingly. And I said, guys, look, there's no crying in figure skating. And they said, yes, there is, and I'm like, and then I had nothing, so it's a challenge to keep up.
What about you?
You had the perfect analogy there. Being a coverage lawyer is a lot like figure skating when you get into court, because the other side just kind of keeps going round and round and round on the same three arguments over and over again until you figure out a way to just knock them over and cut through that circle there.
Yeah, that wasn't a Tanya Harding reference, was it?
What about you, Laura? How would you describe what you do to family members?
Well, I tell people this a lot because nobody knows what a coverage and bad faith lawyer is. So what I usually do is give people an example of if they had a car accident and they notified their insurance company that the insurance policy would most likely provide a defense. And if, say, the insurance company said that there wasn't a defense or there was an issue as to whether there was, those sorts of issues are the things I deal with, determining whether a policy, my light just turned off, determining if there's a policy that applies so that they can understand it in a context. And I'm going to have to wave my arm around to turn my automatic light on.
Yeah, go ahead. I have to do that too. I have to go like this to turn on my, there you go.
Apparently I'm not moving around nearly enough. So, and then just to follow on what Scott says, one of the things I find the hardest is educating the judge. If it's an easy coverage issue, as far as what the issue itself is, it's not too bad. Like, for example, a classic one is intentional acts. Everyone can really understand the issue of whether something was an intentional act, and then you look at the facts and you go from there, and the case law. But some of these are much more complicated, and you have to really walk somebody through how to get from 1 to 2 to 3 to 4. And I find that challenging in a good way, though. It's always something that I find it very useful to be able to be straightforward and to respect the intelligence of the judge, but also to recognize that if they don't have a background in this, a lot of this stuff is very confusing and complicated. So it's a continuing challenge, both orally in court and in writing, but one that I enjoy. And I think that's, probably true of everyone else on this call except you, Tricia.
I agree with that 100%, because particularly in the state court system, where we are, they may not have a lot of law clerks, and it's not that the judges aren't smart, because they are. It's, they may have had a criminal practice before they took the bench, or they may have had a family law practice. And so we've had many times when we've argued cases, summary judgment or whatever, where the judge will have said, this is my first insurance case ever,
Wow.
And so when you get in that situation, you may have a conversation with your client who may be a very sophisticated claims counsel, knows the underwriting history for the last 25 years on this particular provision. Like, you don't understand, sometimes we have to make this explainable to people who have never even dealt with this before. And that is a big challenge.
And that's so interesting because like I can see that perspective. So I handle a lot of premises cases, and premises you don't have to you don't have to do much explaining on the law. You know, judges have seen those for years, so they get that. But when I deal with my product liability stuff, my more complicated GL stuff, there is some sort of learning curve. And how do you do that? It's tricky because you don't want to be condescending and you want to make sure that you're telling your story. Do you guys have to do that in the coverage world? Is it important to tell a story? I mean, how do you deal with your messaging to a judge who doesn't understand what you're doing?
Let me jump in on that because I think with any case, you have to have a story or a narrative coming in here. And the insurance world is no different. If you don't come in as a trial lawyer and be able to say, here's our story, judge, in 30 seconds or less, you're going to have a much greater uphill battle. But here's the question I'm more curious about, and I'm going to throw out there to everybody else. Because one of the things we do when we get a coverage case and we know it's in suit is we do a lot of background work on who the judge is. And then we'll try and, to the extent possible, tailor the arguments or how we're going to make the arguments to what the judge's background and practice is. So, you know, if we have a judge who has an extensive criminal background, obviously an intentional act is going to be much easier for him or her to understand. Or an arson case, then coming in here to try to say, okay, now you need to learn whether or not an exclusion for a collapse really means it's a collapse or a partial collapse, and you know where the periods and commas and all that other fun stuff are. But to understand where the judge's background is, I always find to be interesting work and something that the judges can appreciate, to be able to tie in what they've done before to a coverage world.
Yeah, I agree. I agree with that, and I think, you know, maybe part of that too, you know, if we have a little bit of background in insurance, is when we're arguing over what a provision means and does it or does not apply, you can get lost in the word games so quickly, you know, and it becomes like 10th grade English class, and you can go for 25 minutes and no one understands what anyone's talking about at the end of it. It's helpful also, I think, you know, talking about the underwriting and the background is to have a perspective on, you know, judge, this is what this provision is supposed to be doing. This is what this policy is supposed to cover and what it's not supposed to cover. And that doesn't always prevail, but I think some perspective on, well, wait a second, let's just kind of step back. What are we really dealing with? This is an auto policy. It's not supposed to be covering a slip and fall, you know, that sort of thing I think can also be persuasive to folks that are like, yeah, I haven't done insurance before, but that sounds right. I don't, why is this covering that?
I love that. I think that's so on point, because to give the people the why, you know, there's all this talk in business, like know your why. To give the people of why something is happening, I think it can be interesting, and it grounds it in a reason of why that battle is happening in the first place. I think that's such a great point. How about you, Laura?
I think it's also, I agree with what both of them have said. I think it's important because most people think that coverage is boring, and I think most judges would fall into that group. There's the exception, but so that you need a way to kind of pull them into the case. And some cases it's certainly easier than others, depending on the facts that you have at issue. But making them understand from the beginning in a few sentences what the case, you know, the actual underlying case is about, plus what the insurance issue is, so that they know from the beginning sort of where you're going and have a context for it. I think that's very important. Certainly it's a different spiel, so to speak, if you're dealing with a jury. And most of my coverage cases end in summary judgment, not all, but most. And there are a few that you end up with fact issues where you're on a coverage case actually before a jury. But primarily it's bad faith cases that you're on those, and they may have a coverage component, but more often than not, it's something else. So that's a different scenario.
And I was going to ask that, how often are you in front of a judge versus in front of a jury? Because like for me, we're always a jury. I mean, unless somebody asks for a waiver of a jury, but that rarely happens. But for coverage, I understand it's a little bit different. Can you guys talk about that?
Varies a lot by jurisdiction. You know, obviously if it's summary judgment, it's a judge. So oftentimes in my experience, if it's a straight coverage case, the facts may not be an issue. Also, just to clarify, if we're talking about a third party case and you're talking about a duty to defend, then the facts are the allegations by the plaintiff. So it doesn't actually matter if they're true. They are taken as true for purposes of duty to defend, and then you have no fact issues, assuming that everyone agrees what policy is in play. So in that respect, you're much more often to have a judge than a jury in a coverage case. Bad faith, that's a different ball of wax and varies a lot by state.
And I want to talk about that later. I want to put the bad faith on hold, but Mike, what about you?
Yeah, well, if it's a straight up coverage issue, more times than not, that will be a judge issue. Missouri's a little bit different. I mean, well, that's an understatement, but we're kind of like, for insurance, we're kind of like Florida without the good weather. Sort of a difficult place to be, but we also take into account extrinsic evidence in Missouri for duty to defend. Illinois, we don't think so, except when you do. But
yeah, that's true everywhere.
So for the most part, we're in front of a judge. The bad faith cases, when those do go, and they don't go that often because of the exposure, obviously those would be jury issues.
Matt, what about you?
See, for us over here in Pennsylvania, it really comes down to the jurisdiction, state versus federal court, at least for the bad faith. I know we're putting that aside, but it also blends into the coverage as well, because one of the things that I think a lot of people don't appreciate with the coverage work is how much more of a chess match this is than your typical liability case, where, okay, you have pieces of evidence in terms of, liability, maybe a credibility issue. Do you want to spring this on the opposing party now or later? In the coverage world, we got to be thinking so much farther ahead in terms of, okay, do we want to have the carrier try and join into that intentional assault case where there's like the one allegation of negligence, so we can make sure a verdict sheet is molded appropriately? Or, okay, how are you going to make an accountant seem very entertaining to a jury when you're talking a business interruption claim versus an owner of a company, going back and forth? So there's a lot more nuances, I think, with the coverage world. And Mike, I feel your pain, because there are plenty of places in northern Pennsylvania here that are a lot like Missouri in terms of the weather. So we definitely don't get the warm, sunny Florida weather, that's for sure, more often than not. But here's the other thing that I find just as challenging with the courtroom, and it's more than the law, more than the judges. And I'm sure you both can chime in and hopefully agree with me on this. Some of the worst law in the insurance world was made by people who aren't coverage lawyers and are just making arguments that may have emotional appeal to them, or they're making form arguments without either understanding the evolution of the policies, or are, just they don't appreciate the fine details that we do. And they look at something, they say, wow, this sounds really, really good. Let's argue it. That's how appraisal in Pennsylvania got kind of turned on its head about 6-7 years ago, was because someone made a decision and said, hey, this looks like something really good. Let's do it. And a federal judge kind of had the foresight to look down the road and say, okay, I'm going to go with the carrier on here because I know the long-term effects are going to be more for the policyholders and to their benefit.
Yeah, I think so too. I mean, it's not uncommon when we'll get an opinion from the appellate court. We'll read it and we're like, my goodness, who took that position? It's like the Lone Ranger. Who was that masked man that made that argument? And so that's a point. And the other one, and I know some people, this becomes almost as controversial as certificates of insurance, which I won't get into because that gets people fired up. But is, when insurance companies have disputes with other insurance companies, and then we file lawsuits where we take positions that we normally wouldn't take, some of our most difficult law in Missouri is the result of that. Instead of carriers arbitrating with one another or coming to an agreement, they go to the courts and they may win that particular case, which is amazing. They're going to get some money back. But now they're stuck with some difficult case law that they're going to have to deal with for the next 40 years. So I think that's something too, where some bad case law can come up.
So lesson from this, if you're not an insurance coverage lawyer, don't be handling insurance coverage cases and creating bad law, right?
Well, I think the other problem is that when you have those non-insurance coverage lawyers doing those things and you have a judge that doesn't have the background, maybe doesn't have a law clerk to really delve into things, you can end up with even some weird tangent on what the non-coverage lawyer was proposing. And we've seen a few of those that have really thrown things out of whack in the New England states, and it's taken a number of years to get a case back up to an appellate level that addresses the issue, which has really caused problems in the meantime.
Well, think of the cases you had not too recently in Connecticut with all of the defective concrete. I've been watching those down here, you know, hoping a lot of the earlier decisions didn't bleed down, but by the same token, I'm scratching my head going, how are they finding there's coverage for this? I'm reading through the opinions and they're talking about spalling and not spalling. And I'm saying someone's missing the point. And thankfully, at the end of the day, the court finally got it right, you know, and issued the opinion it should. But it's kind of, you know, one of those where you watch it in the beginning stages and you go, I don't know.
Right. And I think on Connecticut, there was something like 15 years in between those.
Absolutely.
Yeah, so it was a lot of time where things were done in a way that didn't necessarily make sense.
Well, so let's talk about some of the unique challenges that face coverage lawyers and claims adjusters that are handling first-party claims. What do you see that's unique to the coverage world that, say, the GL world or the other types of litigation that they don't have? I'll throw this one to you, Michael.
Well, and to be candid, I don't do a great deal of first-party work, but when, you know, even with the third party stuff, when you're in a bad faith case or state like Missouri is, you know, the adjuster, the claims professional are making various decisions. They're investigating, they're looking at everything. And then when something goes wrong, and sometimes they don't know which claim is going to blow up on them, and it becomes a difficult case that now they have to deal with for the next 2 to 5 years. It's very much like a Monday morning quarterback analysis that's going on. Everything that they do is scrutinized. Why didn't you call this guy? Why didn't you talk to the insured? You know, did you call underwriting and ask, you know, and it's very easy, and I could see this in the first party context as well, for it to become so personal, you know, with the claims person. Because, you know, if I'm a lawyer and I get sued, I'm going to take that personal. And the adjusters do too. And so that is one of the big challenges is working on these cases, is to understand that and to kind of work through that. You know, and when folks show up at deposition, I tell them, like, look, you're going to get mad, you know, during this deposition. Don't do it on video. You know, let's go out in the hallway and you let me have it. And they're like, don't worry, I was going to do that anyway. But, you know, but it's so personal, and to be able to, you know, talk and work with people and to get past that and to represent the company in the best way possible, that's a huge challenge.
I think that's also getting worse in some respects because several of these states across the country are now allowing suits directly against the claims handlers, which really ratchets things up when people are, you know, just doing their job. So I think that's an area that we're going to see some changes in. It'll be interesting to see what those are.
That's crazy. Adjusters getting sued personally. Mm-hmm. Is that what you're talking about?
Yep.
That's crazy.
Yeah, it's been going on in Pennsylvania for some time. A lot of times the adjusters can beat that early on, but it depends on what exactly their role was and what the allegations are. But let me just add on and kind of, Mike, I take a little bit of a different tack than you in terms of the adjusters who, you know, really show that emotion. When I get them into a courtroom, I say, show it. You know, my cases aren't about, you know, this monolithic insurance company. It's, here's John Smith. You know, here's the adjuster. He's trying to do his best for this claim. Here's what he needed. Here's what he got, and kind of really humanize it around that person or that process, especially where you have fact issues and bad faith cases, you know, where a jury may be getting involved. You know, I've had so much more success by humanizing the carrier through its adjusters. And let's be honest, they're great men and women who work there in a oftentimes tireless job. You know, they're right up there with teachers. They get berated by parents all day long about things that they think their kids are entitled to, when the reality is, well, that's not what they purchased. You know, you can't get coverage for everything when you've got the most basic of policies. that only lists these, 11 perils that are going to be covered. And sorry, this one isn't it. So, but the other thing I think that's, to get back to the challenging part of this job, it's managing the business practices with the individual claim, because a lot of times they may not always marry up. What may be a good business decision for one particular claim may have broader business practice implications in the future, whether it's turns into a pattern and practice argument on the first party side. And we've seen a lot of that in Pennsylvania, where the plaintiff's attorneys who do the property insurance work and the public adjusters, they all talk amongst themselves. They know who the carriers are they want to target. They know the issues they want to target. And they've gone so far as to have spreadsheets based on policy provisions, adjusters, and issues, so they can say, okay, this carrier handles claims differently out of its Harrisburg office, from its Philadelphia office, from those that may be up in Allentown. And then they're using that to build the argument to get towards that bad faith claim. So, managing that big quagmire and trying to say, okay, here's what's the best decision possible can be a real challenge.
And I have to say that I remember, in 15 years ago, my 1 year of coverage experience, Michael, I remember that.
Which was the best year ever.
The best year of my life. I don't know why I got out of it. But that's what I remember is every word, like the emails, the claims adjusters, the timeliness, how long between they communicated, if they responded, like they were microscopic examinations of what they did, Monday morning, right? I remember that you get a little bit on the GL side, more just internally. If a claim blows up on the GL side, you get your supervisor doing that, but you don't get the judge doing that. So right. I think that's definitely something that I would see very specific to the coverage world is you really, even the claims people have to be meticulous. Yeah. And they have to know how to navigate the rules within their jurisdiction to make sure they aren't setting up a bad faith claim or something like that. I do remember that.
Yeah, it's in a lot of ways it's unfair, because you have an adjuster in a deposition being asked questions by a plaintiff's lawyer, and you listen to well, you didn't do this, you didn't do that. I'm like, you know what, dude? Are you trying to tell me you write everything down in your cases? Do you call your clients back within 24 hours, like you say on your website? I don't think so, but we're the insurance company, and that's just the way it is. And so we just have to do the best we can and get people ready for it. But you're right, it's a very challenging job. There's no doubt.
Well, let's move into the bad faith part, because I think bad faith, and tell me if I'm wrong, bad faith mirrors kind of like a punitive damages claim in the GL side. And I don't think the GL side handles it as much as the bad faith claims in the coverage world. So can one of you take a stab for me, just describing what a bad faith claim is, and then how do you handle that pressure? Because you're the one advising often insurance companies if their conduct is going to meet that standard. So how about Laura? I'll throw it to you. How would you define bad faith?
Oh, sure. Give me the ugly question. Well, first of all, I always find the bad faith label to be a bit confusing. So I oftentimes start with that really bad faith is the flip side of good faith. And what that standard is varies hugely. Most states have some sort of a Unfair Claims Practices Act, but a lot of states, the only actor that can bring those claims are the Commissioner of Insurance. So those states are vastly different than states like Massachusetts, where an individual can bring the claim in a variety of different ways. So that's a big difference. There are also, in many states, possibly all, common law claims that would generally fall into that bad faith description as well. So it varies a lot state to state. Generally, I think to get punitive damages, you need to have a statute that lets you do that. I can't say for sure that there's nowhere that lets you do punitive damages through common law, but it's certainly much more unlikely. And maybe Scott or Mike have experience with that. But I think the thing that makes bad faith scary is that there is that possibility of multiple damages. In Massachusetts, not only can you get triple damages, you also get your attorney's fees if the plaintiff is successful. So the potential downside to an insurance company is significant.
Let me ask this real quick to Laura and Mike. Over the course of your careers, how many, and without obviously disclosing names and protecting the innocent here, honest to goodness claims have you seen where you scratch your head and say, wow, this one really is a bad faith claim, like as objectively as possible? Because as I reflect back on my career, I can really only think of about 3 occasions where when I remember looking at a file and just kind of going, oh, that's bad. Kind of like when you eat some food and someone says, here, try this. And you say, yeah, why not? And you get that, type reaction to it.
And let me just interrupt you. From my perspective, bad faith is insurance company is acting poorly. I mean, is it that simple, or is it more complicated than that?
And let me just add on to that real quick. From my perspective, it's not necessarily were they acting poorly, were they acting reasonably? You know, if they're asked the question, why did you do something? And they scratch their heads and say, I don't know. Well, it's not bad faith, but it's certainly starting down that road. If they say, yeah, here's what I did and why, you know what, that gets into that area where, okay, it's probably not going to be a bad thing.
Yeah, and I think when you talk about defining bad faith, particularly maybe on common law claims, it really depends on your jurisdiction. And by the way, that's my weasel answer when I do podcasts and DOEs. It depends on your jurisdiction, or it depends on your policy language. There are some states, my understanding, they're very difficult to bring bad faith cases, like New York and Illinois, maybe in that category. And then there's other states, Florida and Missouri, and so some of these states that are difficult, the standard will be, did the insurance company in making these decisions put its interest ahead of the policyholder? You know, that's one standard. That's actually the Missouri standard.
I don't like that standard.
I question whether or not we really follow it or not, but other states may do more, like Scott's saying, more about a reasonableness thing. So it really depends. And like the original question, how do you advise insurance companies in these particularly difficult bad faith states on what they should do with what their exposure is? And I do a lot of my work in the fetal position on this stuff. I'm just kidding, sort of. It's like any other claim in a sense, except it's against the company, and the risk can be incredible. And so you're really trying to do your best based on prior cases, based on claims handling, based on your experience, to kind of evaluate, on a scale, how bad is this one? Because like the question, how many bad faith cases have you really seen where the insurance company really put its interest ahead of the policyholder? I've seen like one. And it was a pretty good one. But besides that, you don't see it, but what you have is a series of claims handling decisions that in retrospect are not perfect. Mistakes are made. And
right. So I think the retrospect is a big part of this too,
yeah.
Because one of the problems is that if you have somebody make an analysis of, say, liability or damages at 0.2 in time, that turns out to be just way off. This is one of those, 5% of cases that ended up with a much bigger verdict than was anticipated. Then looking at the bad faith side becomes different. It shouldn't, because those decisions were made based on information at that time. But I find that oftentimes the cases that really hit big, in addition to being big damages cases against, in the underlying claim, are also ones that they just didn't guess well. It didn't mean that their guess was unreasonable. It just didn't turn out to be the case. And if you have the 1% of cases and, they say turn down a settlement offer that if everyone had full information later, everybody would have, on the insurance company side would have been happy to take that. But you don't have that information. And I think we need to, one of the roles is always reminding people what information was available at the time different decisions were made, because you didn't have the information that you have after trial.
But doesn't that make the third party excess verdict bad faith cases even that much more challenging, do you think? Because when
I think
come
so.
in, the story's already written. You already know what the final number is. And the question really becomes one of two things. A, how early could you tell the damages and that they could potentially get over that policy limit, whether it's a personal lines, whether it's a commercial lines policy, a professional lines policy. And then what are your liability chances of success? And I'm always amazed at, well-respected lawyers, well-respected firms, when I look at some of these cases and I say, well, all right, suit comes in on, February 1. You don't do an analysis of the potential exposure until 12 months later. You know what the injuries are. How do you answer, this is a rhetorical question, in front of a judge or jury later on? Okay, we have access to so much data and information. Plug in the injuries. What are the jury verdicts in that area? It's not perfect, but it's a starting point. And it allows everybody to say, okay, here's the range we're talking about here. Either plaintiff's counsel's off on another planet, or maybe this is a case we need to be concerned about now. And is there a path out of it sooner rather than later?
Well, do you think that the bad faith claims that you see, is it more of a manufactured claim by the plaintiff's bar? They're legit. Go ahead.
There are certainly some of those. In Massachusetts, because of the ability to get triple damages in the right case and attorney's fees, a lot of plaintiffs' attorneys file these claims all the time. And it also tends to make an insurance company pay more attention. What was a small case becomes a case against the company that, at least in the best circumstances for the plaintiff, could be a big money case. So I think more of the cases that have those get settled. Some of the problem that we've seen in Massachusetts, which is evolving, but is the whether or not the insurer is able to sever the bad faith claim from the underlying claim. Because a plaintiff in a third party case can bring the claim directly against the company from square one. And historically, we could always do that. Was a non-issue. Plaintiffs' attorneys would agree to the motion, and in the last few years, that's been changing some. So it's changed how these cases are handled to a great extent by both sides.
Yeah, in Missouri, if it's not a manufactured judgment, they're just not trying that hard. It's like they're disrespecting us. I kid. We have a statute in our state. It's 537065 that allows plaintiffs and insureds to basically do in deals where the insured has no exposure for the judgment, and they can therefore enter a consent judgment and go after the carrier after there's potentially been some bad faith claims handling. And this statute, I like to say the plaintiff's lawyers in Missouri know two numbers, 867-5309. After that Jenny song.
It's a great song, by the way.
Yeah, and the other is 537065. And we have really a culture of setting up carriers, and it's built right into the statute. And there's been reforms to it, and have the reforms taking effect, and it's really a huge battle. But we're on the Missouri side. That's the insurance company's perspective, is that so many of these are manufactured. The stuff we do in Illinois is very different. In the bad faith cases over there, those, a lot of those cases are being tried, underlying cases. You're getting excess verdicts, and so, it's just a river that separates our two states, but two different worlds.
Now, here's something, Mike. Let me ask you this: with regards to those claims that are manufactured, and I noticed one of the trends that seems to be taking hold in the courts is whether or not the insureds can maintain a separate action against the defense counsel as well.
Yeah.
The carriers can bring an action against the defense counsel saying you screwed this case up. Me personally, I can't think of any time where I had brought a direct action against an assigned defense counsel in a case saying, okay, here's all the things you did wrong, because I always felt that increased the exposure to the carriers saying, okay, well, if you see this now, why weren't you doing something more proactively back then? But I guess that gets to the question of what can you, if you were to have to put forth any type of suggestions for, I don't want to say fighting back, but trying to help get ahead of those manufactured judgments, because we've got lots of suggestions by the time we're in there in the bad faith case. But in terms of to the people out there, say, okay, here's what you can do to kind of get ahead of the curve on those.
Yeah, I think it's, it's kind of just doing a good job. We advise people all the time, look, we're not telling you to do anything different than you normally should be doing. Following your claim guidelines, investigating diligently, communicate with the insured over and over and over. When a policy limit demand comes in and we don't send it to the insured, it's tough to defend that. It's tough to come up with rationales for why that is okay. If it happens, it's usually just a mistake and oversight, et cetera. But it's really being diligent, communicating, offering to settle the case when we should. If there's coverage questions, how are we handling that? It's really about, I think, if this case blows up, and sometimes you just don't know which one that is, and we have to try it 5 years from now, what does our record look like? Did we do a good job with the claim notes? Did we document? Did we not put stupid incendiary things in the claim notes? One sentence can blow up an otherwise perfectly fine claim in the claim notes. So those are the kind of things that, we typically advise folks.
What do you see? Well, there's such a big thing now about social inflation, nuclear verdicts. Do you see that impacting your bad faith claims or even your regular coverage claims? Do you see that as an increased, more of a concern nowadays?
I think so, because I think a lot of people are evaluating the value of claims based on the understanding of a couple of years ago. And where we are, particularly in St. Louis City, where you have all these talc verdicts that were coming in that ultimately were taken away by the Supreme Court, there's that social inflation is really driving the value of claims. And so I think it is an ongoing process to say, look, this looks like a soft tissue case with very little medical. Is it really worth the $100,000 limit? A couple of years ago, the answer might have been different than it is today.
Well, I think the hard part about that, especially, is the potential for excess verdicts in situations where a few years ago there wouldn't have been a concern about an excess verdict. So that creates a new potential problem for the carriers and, of course, for the insureds when the limits may not be enough, when 4 or 5 years ago for the same injury they absolutely would have been.
Yeah. I think another strategy that sometimes we recommend if the case is right, and this is something that 5 years ago we would have been fired for recommending, is that sometimes carriers will now do these so-called blue sky agreements or safe harbor agreements where they'll say, look, we're going to pull the policy limits, we're going to pull our coverage defenses, and we're going to try this case. And we're going to see if the plaintiff can really prove up that the case is worth X. And it's amazing in the right kind of cases how cases settle that wouldn't if they had the bad faith or the coverage leverage over us.
Are you getting involved, Mike, you or Laura, in more of a coordinating counsel role with the carriers for the liability case? Because that's one thing I've started to see more of, but the drivers of that aren't so much the case itself, I've been finding, but rather the carrier's concern over something its defense counsel is doing, or as is often the case, not doing. Let me give you a great example. I got pulled in by one carrier a couple of years ago into a construction case in New York where its defense counsel, there were two law firms, were almost completely off the grid. We were talking 2-3 months of no communications, no response to carriers' questions. Now the carriers left with a couple of options at that point. So what they did was they brought me in to say, okay, help us navigate through this process. Okay, step in, because there were some coverage questions, some real legitimate coverage issues. But because I was brought in that kind of coordinating counsel, or my client's the carrier, not the insured, I could talk both the liability and the coverage and get everybody to a point where we say, okay, now we're in a mediation. this person who's, maybe not be doing the job that they should have been, which honestly shocks me nowadays, to help bridge that gap and kind of help the carriers to avoid the excess claim down the road. Is that something you're seeing more of now? Or
I'm certainly seeing that. We do a lot of work nationally for a particular carrier. And one of the things that we do is sort of make sure that things are handled the same, whether it's a coverage issue. Bad faith issues, again, are more jurisdictional. So, but making sure that defense counsel is not creating liability for the company that wouldn't otherwise exist. And I think in situations like you were talking about with, say, maybe a defense counsel that's not responsive to the carrier, that I've been in those situations where, once we've kind of inserted ourselves into the situation, they've become more responsive, which is a good thing, but shouldn't have to happen either. But certainly something that I've seen more in the last 4 or 5 years than in my previous, 20 plus years of practice. So I don't know whether defense counsel are having more issues or whether carriers are more aware of it, or maybe they're finding using outside counsel to do that is more effective. I'm not sure.
So there's a couple questions that I want to make sure we get to because we are running up to our time, but what advice would you give to a new coverage claims adjuster or a new coverage defense attorney? Just give me one takeaway that you would tell them to either help them do their job better or make their job easier.
I would say in the claim notes, write them like a jury is going to read them. Don't think of this like the email that you quickly whip off to your best friend. This, the language is important. And over the years, I've seen so many things in claim notes that should never have been there, like characterizations of people, personalities, things like that really don't help you later.
How about you, Michael?
Yeah, I agree with that. It's so much on the claim note front. I have this saying, for the claims folks, dance like no one is watching, but write your claim notes as if they're going to be read aloud in your deposition in 2 years. I think it's a lot like that. And then for, young coverage lawyers, honestly, it's just reading the whole policy. So many times mistakes are made because people get excited about an occurrence issue or an exclusion. Reading the whole thing front to back, looking at the decks. Do we have all the forms? I mean, that wouldn't be the first time that happens.
Yep.
With policy, there's something missing, or there's something there that shouldn't be there. Just being very diligent and reading the whole thing, because it's difficult to explain later. Oops, we totally missed the issue because we didn't read this particular form. So just being diligent and reading the whole thing, I think, is so important.
I would also add to that to the extent there's a cover letter in existence anymore, the cover email now, try not to read that and to read the file first, because oftentimes you usually get a case that has one particular problem highlighted. That's the reason it's coming to you. That may not be the only issue. And if you go into it looking for that, you may not see something else. So I try and avoid the characterization in advance and go through everything, come to my own conclusions, and then go back and see what the person sending it to me had highlighted.
Yeah, that's a good point. It wouldn't be the first time that someone said, hey, could you look at this and see if this exclusion applies? And it's like, oh, by the way, you didn't respond to 8 settlement demands. That's probably a more present situation.
See, now I'm going to go in a completely different direction here for the new coverage lawyer, and even for the in-house coverage folks who are looking at these issues. They have to understand what the process is. Now, I'm not talking the insurance process itself, but what they're looking to exclude or deny coverage on. Case in point, sitting in a hearing not too long ago, arguing a defective workmanship issue. Good lawyer on the other end knew nothing about how the building was built. And they had basically the experts run circles all around them because they knew the structure. They knew the mechanics of it. They were so much more persuasive and effective. On the flip side, where you have an adjuster or someone who can come in and say, okay, You know what? I used to, and I'm just going to use the first party property world for a minute. I built homes before becoming an insurance adjuster. Here's how this works. Here's the costs for all of this stuff in this area. And here's why all of these other things are unnecessary. Suddenly that adjuster has so much more credibility to be able to make that case persuasively and tie the knot. It's not just about the policy exclusions I find or the provisions. They're important. They define exactly what we do. But to be able to connect them clearly and coherently to what it is that's at issue, I find to be most challenging. You know, intentional act. Someone says, oh, this person was drunk. So, yes, so? Were they at the point where they didn't understand what they were doing? At what point did they lose control? If they don't know the questions to ask, they're not going to get the right answers to make the correct coverage decision.
Well, great tips, guys. I do want to end with two questions. One, I'm dying to know myself. If you can give me in a 2 or 3 sentence, because I know we're running on time, which is incredibly hard to do. What's your craziest coverage claim? It could be facts or legal, whatever it may be, that, you know, people think all you guys do is sit around and read policies all day, but it's actually a lot of very interesting claims. What's your most interesting?
I just had a recent one that the coverage part of it was a number of years ago, but the underlying criminal case just went up through the Massachusetts Supreme Judicial Court with the decision upholding the conviction a week or so ago. Involved a homeowner's policy. Father and son conspire with mother's brother to kill another brother to get a bunch of inheritance that the father named insured thought he was entitled to. And after the criminal, father ends up getting exonerated, son pleads guilty, uncle, who was the actual shooter, gets convicted, and his conviction just got affirmed. In the meantime, there was a civil case to get the inheritance by the other sister who wasn't involved. And the question was whether the son, who had pled guilty, was entitled to defense under the policy, which included a intentional harms exclusion. Was a little bit of a different one than I usually see. And it was also what I was thinking about when Scott was talking about telling the story. My summary judgment judge had a former criminal background, had no insurance experience at all, was new to the bench. And so I told the story in a way that made it clear that this was an intent, and this was an intent to cause harm. Would I have told it the same way if it was a different judge? Probably not. But was successful on summary judgment, and I understand the civil case ended up giving the remaining sister all of the inheritance from the parents. So
that was probably not a boring claim to handle.
So not a boring claim, but I think the intentional acts ones tends to be the most sexy coverage cases. But that's mine.
How about you, Michael?
I don't talk about too many of my cases, because a lot of these never reach a court and we're just evaluating and so forth. But goodness, 4 or 5 years ago, we would have one case after another for some inexplicable reason where different people just kept videoing other people in the bathroom, And I know we're in Missouri and we're the home of Chuck Berry, but still this is getting completely carried. And it was just like, what is going on? And, so we learned a lot about coverage B and personal and advertising injury and invasion of rights of privacy with publication in those cases. So crazy stuff.
That's awesome. Well, not awesome that it's happening, but right. You know what I mean. How about you, Scott?
I would say the most interesting case I had was a trade credit dispute. I kind of mentioned a little bit about that in the beginning, but it was an alleged fraudulent transaction involving an insured entering into an agreements with other companies in Mexico to sell goods. But we had, as the parties, we had a bunch of German banks. We had a foreign insurance company that was based in the States, and then companies that were in Texas and Mexico. So I had to go back and learn about the Hague Convention to be able to get depositions out of the country, all kinds of interesting things, and tie that all up with how are we going to make this a fraud argument was really, really interesting to say the least.
Well, great discussion, guys. I have to say that for anybody looking for coverage lawyers, these three are your people, your peeps. They are heavily on LinkedIn, and this is what's great about them on LinkedIn. They just give great value and content. They're not selling or pitching. Scott, Laura, Michael, they all post, I think, every day or at least a couple times a week about the claims that they're handling or coverage issues. They're really just trying to elevate, I think, the industry in general, which is great. So make sure you follow them. I will drop their contact information in the podcast notes. But you can always reach out to me and I'll direct you to them. But thanks, guys. I appreciate it. I think we could go on for another hour, but we just don't have that time. So I appreciate you coming on. Thank you so much. Thanks for tuning in. Remember to subscribe, like, and rate us. I would super appreciate it. And until next time on The Defense Never Rests, we'll see you then.